Being the Sanctions. And walking. I mean, they had to drive me, question they had to drive me out. Because I been all day. Almost like my kids were just. I still feel like I would be in serious. I see, it's like putting pressure on my legs, my knees, my hips. Just, and if I sit up, like I didn't try. We broke it up. And that, right. She could do. I'll get to. But she said, you will right. Stop. I don't know, a little bit of that. I know my partial. Yeah, this stuff right. Like, just so that what the girls still hurt. What talk? So right now, I hope everything's just yeah. Get enough emotional for that kind of sleep. Yeah, so it's just stress. Oh, yeah, I was triggered. I don't think I was stressed out. I got a lot going on today. Yeah, like you did. I said I need to get here. I mean, there was getting just sitting. I don't want to check that. 5 o'clock in the morning, I can't even pick my feet. Yeah, that is. Keep my eyes right, they're gonna pop out. I think like ready to green box. Energy or energy drink just to try to see each room. How you feel? I like doing it. Well, no, like when you're like feeling right. If I did that. Makes this morning it was 8 of this way about this morning about that. But, so there's none. It's either one or both. Or, it's just I don't know. It's so draining. And then trying to control your body temperature. Because mine won't regulate when I do this. So I bathtub and everything else like that. Regulates some cold. Right. If I have a baby right now, I probably am, but I'm not trying to be. It's okay. As long as it's covering for me, but finding somebody at 5 o'clock in the morning. No, yeah. It's okay, I promise. But I said it's okay, I promise. Well, it's for that. I just lay it out. So. I'm trying to figure out if my husband asked me just I'm gonna go out hours and right here. I want to get to the hospital. So just gonna tell me my liver enzymes are elevated. I've got inflammation, I've got some sort of infection in my body, is what they say, and they believe or something. So it's just I hope you feel better. Right, so you happen sooner or later. So. I wanted to.
What? Look out, but outside.
That I just meant.
This is right inside the jury. All right, now session of the Honorable Chris Martin society. Make sure all your cell phones are off. We won't have them go outside.
Good morning, thank you, please be seated. All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kaylin Cheatham. Nicholas Duncan.
Here.
Kirkland Huggins. Jordan Manning. Mark Manassis. Or Mansanis. Mark Mansanis. Guy McSpadden.
Here.
David Shields.
Here.
Kendrick Willis. Wayne Allen Wingo. Rodney Callahan.
Here.
All right, Mr. Callahan, your attorney, Mr. Barrett, filed a motion for continuance. The court granted that motion, and we are resetting you for plea, I believe, on September 16th. So we'll have you sign a notice of appearance. Make sure, where are you at? Make sure you check in with Mr. West outside. He's the pretrial release officer. You know Mr. West?
Yes.
Okay, check in with Mr. West. We'll have you sign this notice of appearance and you'll be free to go. Have a seat in the hallway and we'll bring it to you.
Sign it out.
No, have a seat in the hallway and we'll bring it to you. Ian Gray. Jerry Brown. Randa Boaz.
She's from the council.
Yes, thank you, Mr. Northcutt. Bobby Cowart. Waiver of arraignment was filed, approved by Mr. Schmidt, and we have set that for pretrial on September 30th.
That 30th, Your Honor?
September 30th.
Thank you.
Daniel Admire. Douglas Bennett. Linda Bennett. Zachary Campbell, have currently in the Kaufman County Jail. We'll recall that case. Tiffany Chance. Ms. Chance will be appearing via Zoom today for arraignment. She is present and logged in. Deanna Dial. Ronnie McGee.
Here.
Norma Mendez. Reno Moreno. Stephen Richardson.
Here.
Michael Rodenbaugh. Michael Lance Rodenbaugh. Edgar Vasquez.
She's from.
Thank you, Mr. Schmidt. Pascal Waters.
Across the hall.
Understand, thank you. Vincent Offered, CR 25101, set for arraignment, waiver of arraignment filed by Mr. Strife that was approved by the court. Pretrial is set September 18th. David Ray Carley, CR 24179, set for arraignment. Mr. Thorson filed a waiver of arraignment that was approved by the court. Pretrial is set September 30th. Bryce Carroll. Brian Lee Hart, CR 25-78, set for arraignment. Mr. White, Jeffrey White filed a waiver of arraignment that was approved by the court. Pretrial is set September 30th. CR 25136, Diel Shapati, I believe is how you say that, set for arraignment. Mr. Nolan White has filed a waiver of arraignment that has been approved by the court, and pretrial is set September 30th. So Ms. Burns, on those that have filed arraignment and have not signed their papers, they have an order to be at your office within 10 days after signing arraignment, but you may want to send an email to the attorneys to remind them. All right, then we have a 9:30, Javier Castaneda. It's not. Oh, he's in there. And then we'll have Mr. Burke's plea and allocution at 10 o'clock. Is there anyone who's in the courtroom, their name's not been called?
Mr. Rodenbaugh just walked in.
Thank you, Mr. Nicholas. Anyone else in the courtroom, your name's not been called? All right, we have any counsel that's ready? Mr. Hard, by your quick rise, you didn't say anything, but I'm assuming you're ready.
Yes, Your Honor.
All right. Jerry Don Brown. You come this way, Mr. Brown. Come to the front, and then you cut right across the front there. Yeah, right there. This is cause number CR 25-31, State versus Jerry Don Brown. Mr. Harden, we are set for pretrial today.
We have nothing for pre-trial, Judge, but we think we may have an agreement, but that will be subject to some discussion with the state. So if we could get one setting for the docket, we will be ready to go.
All right, there being no contested pretrial motions, court sets Mr. Brown for docket call. Mr. Harden, if you have your calendar available, I have September 16th or 18th.
18th, Your Honor.
18th. Court sets Mr. Brown for docket call September 18th at 9 a.m. Mr. Brown, once you sign your notice of appearance, free to go.
I appreciate it.
Thank you, Mr. Harden.
Yes, Your Honor. May I be excused?
Yes. Mark Petter, are you ready?
Yes, sir.
You have just Ms. Boaz.
That's correct, Your Honor.
Brandon Nicole Boaz, CR 22-352. All right, I believe that the court had granted Ms. Northcutt's motion to substitute counsel. I believe that Mr. Schmidt was on the case. He was subbed out. Mr. Hawkins was on the case. Now he's been subbed out. You're here now today, Ms. Northcutt. Is that correct?
That's correct, Your Honor, as of yesterday.
All right. I'm assuming you're not ready for a pretrial hearing to decide whether you filed any contested pretrial motions.
That's correct, Your Honor. If we could get another pretrial date, I'm actually going to go over to the district attorney's office now and collect discovery, hopefully, or at least have it uploaded by the end of this week.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, Ms. Northcutt, September 16th or 18th?
Let me check, Your Honor.
Yes, please do.
What date?
16, 18. September 16th.
16th. All right, court sets Ms. Boaz for an additional pretrial hearing September 16th at 9 a.m. Ms. Boaz, once you sign your notice of appearance, you're free to go.
Thank you. Thank you, Your Honor.
You're welcome.
May be excused
Yes, did she sign her notice of
upon
appearance?
completion of that.
All right, thank you. Any other counsel that's ready? Mr. Schmidt? Who would you like to call first?
So that was ready now.
Do you want to call Miss Chance? She's logged in from California from the rehab. You want to do that one?
That'd be good.
And
my technology. So hopefully I can do that.
well, let's circle back to her.
Let's circle back. That's better.
Who would you like to call first?
Okay. First is Mark Joseph Santos Manzanas.
Mr. Manzanas?
Morning. No English? No English? A little bit, okay.
Mr. Manzanas?
What language? What language?
Mr. Schmidt, can you approach? The court will recall Mr. Gonzalez's case shortly. Mr. Schmidt, we're over two. Let's see if we can get a single.
All right, Ronnie McGee.
Mr. McGee. This is cause number CR 25-135, State of Texas versus Ronnie Earl McGee, and we are set for arraignment.
That's correct, Judge. We received a copy of the indictment. His name is correct. We'll wait formal reading and a plea of not guilty to that as per pretrial setting.
All right, the court finding that Mr. McGee has waived the formal requirements of arraignment, the court enters his plea of not guilty into the record and sets this matter for a pretrial hearing. Is September 16th too early for you, Mr. Schmidt?
Yes, sir.
What about September 30th?
That'll work.
All right, court sets Mr. McGee then for pretrial September 30th at 9 a.m. Mr. McGee, have you met with the pretrial release officer, Mr. West? Okay, then you'll need to sign conditions of pretrial release before you leave. That's Mr. West behind you in that blue shirt.
That's the guy. This guy. Have you met with him, Mr. West? We did. Okay. Has he signed his conditions? Okay, he's good.
Okay.
There's my email address there. Here. Okay, yeah, we'll see you later. So I just walk out. Yeah, walk out the.
Who's next, Mr. Schmidt?
Deanna Dial.
Dana Joy Style, CR 25-129. All right, Ms. Dial is set for arraignment today.
That's correct, Judge. I've received a copy of the indictment. Her name's correctly spelled out. We'll wait formal reading in her plea of not guilty. I'd ask for that September 30th date as well.
All right, the court finding that Ms. Dial, having waived the formal requirements of arraignment, enters her plea of not guilty into the record. Court sets Ms. Dial for pretrial hearing September 30th at 9 a.m. Ms. Dial, have you signed your conditions of pretrial release with Mr. West? You have?
Did you send an email? In a few days, but just send me an email if you haven't already. Yeah, but go ahead and do that. If you don't, you got my email address. Okay, and then we'll coordinate that way. So you take care of your business. We got time. Good. All right. See you later. Daniel Admire.
Mr. Admire. This cause number CR 24-250, State of Texas versus Daniel Jack Admire. And I show that we're set for arraignment on this case.
Yeah. Judge,
Go ahead.
this is a superseding or amended indictment. We've received a copy of that. I don't think there's any substantive changes that require the necessity for a prolonged docket call setting. So in this particular case, we're going to enter that plea of not guilty to the amended indictment, waive reading of that, and just go ahead and announce ready for trial and have it carried on the trial docket as previously set.
All right, the court will enter Mr. Admire's plea of not guilty to the amended indictment and set Mr. Admire on jury selection as previously said, September 8th.
Yeah, and I believe he has a special setting as well. Is that correct? Huh?
April 6th.
April 6th of next year. Okay. Say September 8th. Okay. Judge, you said September 8th for the next jury selection, correct?
That'll be his next report date is September 8th.
Okay.
And he'll maintain the special setting in April. But we have him, Mr. Abraham informed me that he comes every month, checks in on docket call.
Yes, sir.
I'm sorry, on jury selection, meets with Mr. West.
Got it.
Thank you.
Yes.
Mr. Schmidt, I believe Ms. Dial is trying to get your attention.
Yes, ma'am. Don't you have to see?
Who's next?
Judge, I've been asked to announce for Ms. Brumbelow on Ian Gray. Apparently she's ill.
Mr. Gray? This is cause number CR 24-99, State of Texas versus Ian Perry Gray. We're set for docket call. What was your announcement again, Mr. Schmidt?
Judge, according to Ms. Brumbelow, she claimed to me she was still in negotiations over something pertaining to restitution in this case, and she wasn't ready to resolve it. And that she needed to speak to the DA's office. I think the DA may have a different opinion, I don't know, but as far as I'm concerned, I agreed to announce and ask for a reset on her behalf, docket call reset.
Thank
Your
you.
Honor, there's been zero communication from Ms. Brumbelow on this case. The offer has remained from the beginning, deferred adjudication, the length of time dependent on how long it would take to pay back the restitution. Mr. Chamness, the victim in this case, is actually here today, taking time out of his schedule as a prosecuting attorney in Smith County. Your Honor, seeing as there's been no communication, state is prepared to announce ready for trial today. And also, Your Honor, beginning to have some concerns. I completely understand medical issues, but I'm beginning to be concerned about Ms. Brumblow's ability to represent Mr. Gray, seeing as this is the sixth time that she's not been unable to appear. I believe this is materially impacting her ability to represent Mr. Gray at this point.
What was the offer, if any, that was made to Mr. Gray? Because I believe I had it set today for final docket call, meaning that if a plea was to be had, it was going to be today. And after today, there would be no plea negotiation. What plea offer was extended to Mr. Gray that has either not been accepted or not been negotiated?
Your Honor, it's for deferred probation. The length of time would just be dependent on how long he needs to pay restitution. Because of the amount of restitution in the case, there was no fine attached to it.
And was that a deferred adjudication on the F3 misapplication of fiduciary financial property, 30,000, 150,000?
Yes, Your Honor.
All right, Mr. Schmidt, I appreciate you standing in for Ms. Brumbelow. Today, the court set Mr. Gray for final hearing on the docket call. There being no agreement today, then the court is going to set Mr. Gray for jury selection beginning September 8th. And Mr. Gray will be on the rolling trial docket. So Mr. Gray, your case will not go to trial on the 8th. However, you will need to be present on that day to sign a notice of appearance and also to check in with your pretrial release officer. You'll continue to do that month to month until your case is liable for trial, and we'll notify your attorney, Ms. Brumbelow, whenever that case enters into the top 10. And that may be within the next 30 to 45 days.
And Your Honor, I know the court's policy about not accepting pleas after setting for trial. Due to the lack of communication, state would ask the court to make an exception in this case if we're able to present an agreement to the court in a prior to trial with enough time so that we're not wasting the court's resources summoning juries and things like that.
Court will take that request under advisement. Should the proper circumstances present themselves, then the state's aware that the court will entertain that.
Thank you, Your Honor.
Mr. Schmidt.
Reno Moreno.
Mr. Moreno. This is cause number CR 24-242, State of Texas versus Reno Santana Moreno for docket call.
Judge, here he is. Okay. Judge, I'm still working through some evidence. on my side, not the DA's side, that I hope to share with them. I did speak briefly with Mr. Hartwell last week about Mr. Marino. Going to ask for a final docket call on his case.
State.
No objection, Your Honor. Thank you.
All right, there being no objections from the state, the court will set Mr. Moreno for a final docket call September 30th at 9 a.m.
I know I have a bill due. It'll be paid Thursday.
I didn't hear what he said, Mr.
He
Schmidt.
said that he understands he's delinquent in some of his pretrial fees and that he intends to pay it on Thursday.
Okay, thank you, Mr. Moreno.
Yes, sir.
I don't have that noted on my docket, but I appreciate you bringing that to my attention.
Well, I paid it all off last month, but
It's in your best interest.
yeah, I paid it all off last month. It's a new month, so.
Yeah.
Appreciate it. Yeah.
Michael Rotenbaugh.
Mr. Rodenbaugh. Clause number CR 25-55. CAs. So after this, I'll bring.
Okay, so we'll just keep going. Hey, we're gonna have that house ready. Okay. Okay.
You ready for announcement, Mr. Schmidt?
Yes, sir. Mr. Rotenbaugh, it's now ready for trial.
All right, and Mr. Rodenbaugh understands that the court may not allow plea negotiations after this date.
Yes, sir.
And what offer was extended, if any, to Mr. Rodenbaugh?
Judge, the last offer we received was 8 probated before.
8 pro 4,
Uh-huh.
any type of fine?
$1,500.
And was that to the indicted charge evading arrest or detention of the vehicle F3?
Yes, sir.
All right. All right, court will place Mr. Rodenbaugh on the court's jury trial docket beginning September 8th. So, Mr. Rodenbaugh, you'll need to appear on September 8th. You will not go to trial that day. However, you will meet with my staff and they will give you a notice of appearance, and you'll also check in with a pretrial release officer.
Yeah, it'll be downstairs. Move on your page. Okay. I heard. I got to call you. My email here. Use it. No, you got mine. Yeah, I got you. Yeah, use it. Yes, sir.
Mr. Schwinn, I need to interrupt you at this time. I need to bring in another case with an interpreter that I have scheduled.
Yes, sir.
Good morning, Holly. Can you see and hear me okay?
Yes, Judge, good morning.
Right, and so today's gonna be a little bit different. Our defendant is an inmate at the Henderson County Justice Center. I haven't brought them in yet. I'm not sure that they're as familiar as we are with the simultaneous translation function in Zoom. So let's bring them in and find out if that's a problem. How long do I have you till?
Until 10 a.m., Judge.
Till 10, okay. You have something right after 10?
No, sir, I can extend by 10 or 15 if needed.
Okay, well, let's cross our fingers and hope that they can do it. I'm gonna bring in the defendant and also the attorney, Mr. Brian. Good morning, Mr. Schmidt. Can you see and hear me okay?
Good morning, Judge. I was just watching on YouTube. Is the interpreter for my case? Because we do not need an interpreter for my case.
It is Mr. Javier Castaneda Jr. who requested the interpreter. So you don't believe that Mr. Castaneda needs the assistance of a language interpreter?
No, sir. We've appeared previously on his case. There's no interpreter necessary.
Okay, Ms. Taberham scheduled it, was under the impression that Mr. Castaneda needed that, so. But as an officer of the court, if you tell me he doesn't need it, then I'm gonna go ahead and let Holly go. I'm sure there's a lot of other things she can be doing.
Yes, sir. I apologize. I'm not sure how that happened. I apologize if it's.
It's okay. Well, we'll make a note of it. So thank you, Holly. Sorry for any inconvenience. Appreciate you being here.
All right. Thank you, Judge. Everyone have a good day.
You as well.
Thank you.
All right. Yeah, Mr. Castaneda will need to be unmuted.
Yes, sir.
All right. Make sure you speak up for me. Can you also see your attorney, Mr. Brian Schmidt?
Yes, sir.
Excellent. Okay. All right. This is cause number CR 25-93, State of Texas versus Javier Castaneda. And we are set for pretrial today. Any announcements, Mr. Schmidt?
Judge, we don't have any contested pretrial with regard to Mr. Castaneda's case. There is a potential 3914 issue that is outside of Mr. Hartwell's control, and as well as the Ms. Palmer's control here in Henderson County. There's an outside agency that is involved. We reset it last time. We reset his Henderson County case yesterday to October 13th to see if those issues are resolved in the interim. So if we could set this off, I don't anticipate any pretrial, but we could set it off perhaps, sometime after that October 13th case. He does have a 25 to life case pending in Henderson County.
Any objections from the state?
No objection, Your Honor. Thank you.
You said October 13th in Henderson County?
That is correct, Your Honor.
All right. What about October 14th or 16th here? It's Henderson County. So Columbus Day is the 13th. Is that right?
It is, but we do have court, Judge. So
Okay.
Any 14th, 15th, 16th would work for me, whatever your pleasure.
All right. Let's do October 14th for docket call.
Yes, sir.
All right, Mr. Castaneda, we'll see you presumably by Zoom again. However, Mr. Schmidt, if something resolves over there and it needs to be in person over here, you'll let the court know.
I will, Your Honor.
All right, Mr. Castaneda, we'll see you back on October 14th, and we'll set that at 9:30 again, Mr. Schmidt. Or actually, let's set that at 10 o'clock. Is that fine with you, Mr. Schmidt?
Sure.
Give me a chance to kind of run through my docket before I go on Zoom.
No problem.
10 o'clock docket call, October 14th. Mr. Castaneda, do me a favor and let the Henderson County Jail staff know. I appreciate their help getting you on this morning.
Yes, sir. Yes, sir.
All right, you have a good day, sir.
You too.
Mr. Schmidt, is that all you have?
It is, Judge. May I be excused?
Yes, sir. Good to see you.
Good to see y'all. Thank you.
Don't you input all the stuff in the system?
Hi,
Good morning. Are you Miss Chance?
I am.
All right, my name is Judge Chris Martin, and I'm the judge of the 294th District Court here in Vincent County, Texas. And you are appearing via Zoom today from a rehabilitation center in California. Is that correct?
Yes, sir.
All right, you do have an attorney in this case that's been appointed to you. His name is Richard Schmidt. And what I'm going to do is I'm going to create a Zoom breakout room. That's a private meeting room for you and Mr. Schmidt to meet to discuss your case preliminarily and to discuss the purpose of our hearing today, which is arraignment. So I don't want you to say anything until you meet with Mr. Schmidt. So, and it may be a moment before he comes in, but I'm going to set up a private room and send you an invitation. I want you to accept it and then just wait. And then when Mr. Schmidt gets in there, you'll have a discussion. After the discussion is over, he'll inform you about your rights and what we're doing today. And after that, we'll come back to court and then we'll make an announcement on your arraignment and we'll discuss scheduling going forward. Does that make sense?
Yes, sir.
Okay.
Yes, sir.
So whenever you see that invitation, accept it and then just wait. He's not going to be there immediately, but wait. And when he gets in there, you'll have your discussion and then you'll return. Okay.
Yes, sir.
Give me just one. Gordon Manning. All right, this is a sanctions court hearing. CR 24247, State versus Jordan, Andrew Manning. All right, Mr. Manning, I believe last time we were in court, you had a few goals. You had to serve 1 day in jail for a positive UA. It says that you did your 1 day in jail. It says you also completed your 15 hours community service. Where did you do that at?
Love and Grace Food Bank.
Okay, what'd you do for them?
Load cars.
Said that you also complied by paying your $75 towards your probation fees and you paid $50 towards your clerk fees.
Yes, sir.
Okay, so what I want to do, Mr. Manning, is I want to reset you for I'm going to reset you for September 30th. And I want you to take a UA today, okay? I want you to have 15 hours of community service done, pay your $75 towards your probation fees and delinquent fees, and pay $50 again towards your court fees.
Yes,
All
sir.
right, so those four things. So you'll take a UA today with Mr. West.
You want me to go that way?
Well, I'm gonna have you sign a notice of appearance, and then yeah, have a seat in the hallway, and then Mr. West will be there with you. Okay? Any
Sir.
questions about those things?
No, sir.
All right.
Want me to wait?
Yeah, just wait right there. We're gonna bring in notice of appearance. You sign that, and then you have a seat in the hallway, and then Mr. West will be leaving. David Shields. All right, it's a Sanctions Court hearing for David Shields, CR 22-363. All right, Mr. Shields, what happened? I let you off Sanctions Court last month.
I missed
Or
two of
June.
my counseling classes. I had a dog die on the first one, and I had to bury it. And the second one, I was actually sick from the sun. Come home sick. I'm a carpenter. I work outside in the sun. I come home sick, and I called called Chuck, told him I was sick, and Miss Mewburn wanted me to come back to Sanction Court because of it. And I assured them both, no matter how sick I am or whatever, I won't miss another one.
All right, so it looks like you're gonna be back in here for a little while. It doesn't look good that I let you out and then you miss your first two counseling sessions. I understand that life comes up, but this is part of your life now.
Yes, sir. I understand.
Now it's a bigger part of your life because it's taking up more time. Not only you're on probation, you're also on probation reporting to this court. So if your dog dies, I understand. You know, if my dog dies, I've got to deal with it and I still got to be here to do my job.
Right.
Part of your job right now is making sure that you comply with every order of this court. All right?
Yes, sir.
It has to be priority or you're going to end up right back in here and it's going to take up more of your time, your freedom, and your money. Okay? So I'm going to have you come back on September 30th. And you have to pay 65 to probation and attend your trauma group.
Yes,
Okay?
sir.
And you know, having your dog die and dealing with things like that, that's a great thing to be talking about in your trauma group. You understand that?
Yeah, I didn't find him till right before it was time to go. And we've had him for 15 years, and I buried him right then.
Yeah, I understand.
And I reassured him I won't miss another one.
All right, we'll see you back on September 30th with those two things being taken care of, 65 in probation and counseling in your trauma group.
Yes, sir. Thank you.
Your Samsung SM5946U. I see me. She's there. We kick you out and yeah, stay right there. Yeah, it says your real name. Here, just see if you can exit out of it because it's locked for me. I can't do anything. Let me try this again. Okay, there you are. Let's try this. Wait. Mr. Wingo. All right, this is a sanctions court hearing for Wayne Allen Wingo, CR 2467. See, Mr. Wingo, you were placed on probation in this court for deferred 5 years, beginning May of 29th of 2024. So you're not set to expire until May of 2029. I've got a note here, a report that you had a positive for THC.
Yes, sir.
Okay. You understand, is this your first time in sanctions court?
Yes, sir.
Do you know what sanctions court is or what its purpose is?
Not really.
So sanctions court is an intervention program for individuals who have been placed on probation, rather than just filing a motion to revoke, bringing you back in here and subjecting you to the state's prosecution and the court's judgment. It's an opportunity for you to try to get back on the straight and narrow and not reoffend your conditions of your community supervision that you've been violating. Obviously, testing positive for THC is a violation of your probation. You understand that?
Yes, sir.
So sanctions court is an opportunity for us to try to figure out what's going on, what's causing the problem, to address it. If you can't address it, then obviously it could result in the state filing a motion to adjudicate you. That means to convict you. Are you a convicted felon today?
No, sir.
Have you ever had a felony conviction in the past?
No, sir.
Is this your first time to be on felony probation?
It's my first time being in any real trouble at all.
So you're on deferred for a second-degree felony burglary of a habitation. I'm repeating things that you're aware of, but just I want to remind you. So you have a potential prison sentence, anywhere from 2 years to 20 years, should you be revoked and sentenced.
Yes, sir.
With that also carries a felony conviction that stays with you the rest of your life. It's not something that you can have expunged. It's not something you can have non-disclosed. It's not anything that you can have removed. And it affects every facet of your life, from your credit score,
Yes.
To your ability to get a good job, to be in a position of trust, things of that nature. Very, very important, very serious. And I hope you don't throw all that away for marijuana.
I allowed somebody back into my life that I shouldn't have, and I've gotten her out of my life and moved on from that.
How do you feel about that decision as you stand here today?
The
How do you feel about your
decision to let
decision to let that person back in your life?
I really hate myself for doing it.
And it wasn't even for her, it was for the child that she had.
But whether her or a child, they
Yes,
didn't
sir.
hold you down to make you smoke marijuana, did they?
No, sir.
Is that what you did? You smoked marijuana? Okay, so they didn't make you do it.
Hmm.
They didn't make you do it.
No, sir, not,
Is there any man on this earth that can hold you down right now and stick
no, sir,
a joint in your mouth and say inhale?
no, sir.
They're not. So no woman and no child's going to do that. You made that decision,
Yes, sir.
right? Okay. So I want to make sure that we're always honest with one another.
Yes, sir.
I'd hate for you to throw away your future for marijuana. That'd be sad.
Yes, sir, it would.
So you need to be thinking about that before you make any decision. So what I want to do today, Mr. Wingo, is I want to sanction you for your violation. That means I'm going to keep you on community supervision. That's why you don't have an attorney here today, because we're not talking about convicting you. We're not talking about revoking you and putting you in prison. I want to sanction you, and I want to amend your conditions of community supervision for a substance abuse evaluation. That means you have to take the evaluation within the next 30 days. And the probation department and their officers can tell you more about how to set that up. And I want you to do 30 hours of community service. Are you currently employed?
Yes, sir, I work at Madix and Terrell,
Okay.
night shift maintenance,
How many days a week do you work?
6 days a week.
6 days a week?
It makes it hard for me to get my community service done, but I talked to my HR, so I should be off for all the upcoming Canton First Mondays, so that way I can at least get Saturday and Sunday done.
Saturday and Sunday?
Yes, sir.
All right, so I'll sanction you for 20 hours of community service. And I want those things done before the week before September 30th. You'll come back here and we're going to meet every month on this sanctions court docket until I feel like you are able to comply on your own.
Yes, sir.
Okay?
Yes, sir.
All right, so we're gonna have you sign a notice of appearance and then come over here and meet with the probation officers and they'll tell you more about how to set up your substance abuse evaluation.
I have to report as soon as I leave here.
Okay, well, sign that and then just go report and then talk to your probation officer.
Okay. So here I can just go to the PO.
Yeah, let's go over to the probation officer.
All right.
You wanna just send it?
Please leave. Here, so. Sit. Yes.
All right, Mr. Schmidt, who are you ready on?
Ms. Chance is still not making the break up. We're ready to proceed.
Hello?
All right, Ms. Chance, can you see and hear me again?
Yes, sir.
All right, we are now in open court and the court is on your case. All right, this is cause number CR 25-34, State versus Tiffany Leanne Chance. We're set for arraignment. A record will reflect that Ms. Chance is appearing via Zoom today with the court's permission. The court has appointed the Honorable Richard Schmidt as counsel for Ms. Chance based on indigency. Ms. Chance has been indicted with a second-degree felony offense of possession of a controlled substance of penalty group 2, greater than 4 grams, less than 400 grams. What's your announcement on arraignment, Mr. Schmidt?
Judge, I've had an opportunity to speak with Ms. Chance. She understands the nature of the charges at this point after speaking with her. Her name is spelled correctly. We'll waive formal reading and enter a plea of not guilty. Ask for a pretrial sentence. And Judge, after discussing with her, she is, as you're aware, in California in a treatment facility. I believe that based on what she's explained to me, that it's a mental health treatment is the basis of that, and that the program is 6 months to a year. We'd ask that we get a little additional time, probably more than usual, for pretrial. In addition, I'd ask that she be allowed to appear by Zoom at our next hearing.
State.
No objection, Your Honor.
All right, and the court will find that Ms. Chance has waived the formal requirements of arraignment. The court enters her plea of not guilty into the record. Court will set Ms. Chance for pretrial October 14th, Mr. Schmidt.
Yes, sir, that should be fine.
Court sets Ms. Chance for pretrial October 14th at 9 a.m. The court will grant the defense request for the defendant to appear via Zoom for pretrial. So Ms. Chance, the court coordinator will send the treatment facility the next setting for your next hearing in October. And
Yes, sir.
You stay in contact with Mr. Schmidt, your attorney, you understand?
Yes, sir.
All right, thank you, Ms. Chance. You're free to go.
Thank you.
You're welcome. Mr. Schmidt, who's next?
Judge, I think the last announcement for now is Mr. Santos Manzanas.
All right, Mr. Manzanas. All right, this is cause number CR 25-133, State versus Mark Joseph Manzanas, set for arraignment today. Mr. Schmidt, any announcements?
There is, Judge. We were able to kind of communicate in the hallway. Obviously, going forward, where he speaks Tagalog, which is the language in the Philippines, and he'll be required to have a Tagalog interpreter. But for today's purposes, his name is correct. We'll waive reading, enter a plea of not guilty, ask for a pretrial setting.
All right, the court will enter Mr. Manzanas' plea of not guilty into the record. The court will set Mr. Manzanas then for pretrial. Do you need more time than the September?
Yes, sir.
What about October 14th?
Yes, sir.
Any objections from the state?
No objection, Your Honor. However, just due to the nature of the alleged offense, state just wants to make sure that there are signed conditions of pretrial release that would prohibit contact with the alleged victim.
Mr. Schmidt, can you see to it that your client meets with Mr. West today?
I can certainly try. Yes, sir.
All right. Okay. All right, court sets Mr. Manzanas then for pretrial October 14th at 9 a.m. and we'll make arrangements to have an interpreter available.
We've got conditions signed, Judge, according to Mr. West.
Thank you.
You understand that? He has to be back here October 14th. So, tell me when to come back. This is my card with email address. Tell them to email me when this whole night. Okay, tell them to send the address. In his own language is fine, and then I'll try to. I got translated. I can see the one. Talk to him that way. Okay. All right. Fine.
You need more time, Mr. Schmidt?
I do. I think the rush speed, please, or something.
Can't hear you. Same coach. Mr. Rosen. All right, court calls number CR 24-199, State of Texas versus Robert Michael Burke. We're set for plea today. Mr. Burke, sir, where you're sitting, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, make sure you speak up loudly and clearly so I can hear you, so my court reporter can take down what you have to say. All right, your name is Robert Michael Burke, is that correct?
Yes, sir.
And Mr. Burke, in this case, you are represented by your attorney, Mr. Kyle Rosenstein, is that correct?
Yes, sir.
Are you pleased with Mr. Rosenstein and the work that he's done for you as your attorney?
Yes, sir.
Do you have any questions about the proceeding or the case or anything else before we go further?
No, sir.
Mr. Rosenstein, do you believe Mr. Burke to be competent to enter into the plea agreement? And if so, have you explained to him all of his rights pertaining to the case?
Yes, Your Honor.
Mr. Burke, are you a United States citizen?
Yes, sir.
You do read, write, and speak English?
Yes, sir.
All right, Mr. Burke, having been charged with a third-degree felony offense of injury to a child, that does carry a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. I see that there is a plea agreement in your case. Upon you pleading guilty to that charge, the state's recommending to the court that the court sets your punishment at 2 years confinement in the Texas Department of Criminal Justice. Also asking the court to order restitution in the amount of $663.26. There is no fine assessed or recommended by the DA's office. You would have court costs of $290 and reimbursement fees of $65. How much credit time would Mr. Burke be entitled to on the plea?
Your Honor, I believe we found.
1 day, Your Honor.
1 day.
That's your agreement, Mr. Rosenstein, Mr. Burke?
Yes, that's our understanding, Your Honor. I would say, Your Honor, I would ask for a finding of indigence and court costs waived in this matter, because I'm doing this pro bono. Mr. Burke has no money.
Any position on that from the state?
State has no position, Your Honor.
And Mr. Rosenstein, I may consider that fact after sentencing, but I would need Mr. Burke to fill out some kind of financial application so I can run a search for assets, income. He'll have to make a sworn statement to that.
I understand, Your Honor. Okay.
All right, Mr. Burke, understanding the range of punishment, understanding the plea agreement at this time, I would ask you, how do you plead to injury to a child?
Guilty, sir.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty in court today?
No, sir.
The court does accept the defendant's plea of guilt at this time. Mr. Rosenstein, any objection to the stipulation of evidence?
No, Your Honor, no objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that victim impact statement has been filed and is with the court, and Ms. Burke is here to allocute today.
And is Ms. Burke supportive of the agreement between the state and the defense?
Yes, Your Honor.
All right. All right, the court is going to, anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
Nothing further, Your Honor.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds that there is sufficient evidence to convict the defendant of the offense. The court will follow the plea agreement. Court hereby convicts Robert Michael Burke of injury to a child, a third-degree felony, assesses punishment at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay court costs of $290 and reimbursement fees of $65 and restitution in the amount of $663.23. Court awards him 1 day credit towards his sentence for the time that he has already served jail on this cause. Mr. Burke, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have Deputy Martinez come and take your fingerprint at this time. Deputy Martinez, there is going to be an allocution in this case, so no need to take him into custody until after the allocution. Also, for the record, Ms. Grisham, the court has received the victim impact statement. The court has reviewed that and signed the tracking form. Harwell, your allocution.
Yes, sir.
Please. All right, the court is directing the court reporter not to record the testimony of the allocution. One of them. Just watch your step, okay? You can move that chair.
I'm just gonna, I wrote it, so,
That's fine.
cool. Bobby, it took me forever to write this. I didn't get it done until this morning because I just didn't know how to do it. I don't know how to differentiate what you did to Addison, who was barely 3 years old, from who you are, because what you did is who you are. Do you know that when I saw Addison's face that morning and asked her what happened, she lied for you? She told me she didn't know what happened to her face. We got to Leah's that day, and all of the girls were so confused. They all asked when we were going home, and I told them that we weren't. They all sighed a big sigh of relief. Emma vocally happy about it. Chloe and Danica didn't say anything, but were visibly calmer and more relaxed. And Addison stared off into a trance, stared off into space, like she was in a trance, like she'd been doing since she lied for you that day. Going forward, Addison, normally super sweet and playful, stayed in that trance, acting out, stealing and breaking Leah's kids' toys, screaming and fighting whoever was around. She was an absolute mess, a completely different person. She would wake up screaming and crying in the middle of the night because she had a nightmare about a monster coming to attack her. Still to this day, she has that same nightmare. It was and is so heartbreaking. But we were told not to talk to the girls about anything that was going on. So how are we supposed to make sure they were okay? This went on for months. Every day we watched as Addison walked around like a zombie and left nothing but destruction in her path. Until one day when I was at work, Leah held her, looked her in the eyes, and said, "Baby, I want you to know that what your daddy did to you was not okay." Just that one sentence. Addison burst out in tears, and when she was done crying, and for the first time in months, her body finally relaxed. And my sweet, playful baby was somewhat back. Emma found out at school that you were arrested. When she asked me about it, she said, "Good. He deserves to be in jail for the rest of his life." And has since that day been vocal daily about how much she hates you and never wants to see you again. And she's actively been trying to make that happen. The rest of the girls have blocked everything out, Addison included. A couple of months ago, Addison told me she missed you because you were always nice to her. It's heartbreaking. She couldn't handle the gravity of what you did to her or the monster that you are, so she blocked it out and painted the picture of you that she wanted. You may have changed your plea to guilty, but that doesn't change the gravity of what you've done. The amount of trauma, confusion, trust issues, anger, and fear that you've put on your children is absolutely heartbreaking. They trusted you. Along with me, you were supposed to be the one other person in their lives that they could count on no matter what to always protect them. But instead, you're the monster. And all of the girls are going to have to live with that forever. And I don't even believe you care. You declined a plea deal because it was going to include prison time. And you decided to change your plea to guilty the day before your trial at the very last minute. What does that look like to you? Like you were scared of the outcome of the trial, not like you actually cared about what you did to your barely 3-year-old child and how it affected all of your children. You used to tell me that if I ever tried to take them, you'd find me and you'd kill me. I remember one time in particular like it was yesterday. It was a couple of months before you beat up Addison. We were standing in the kitchen talking about how Leah mentioned that the girls and I should move in with her. You kept pushing me to do it, but told me that I wasn't taking the girls. And I told you that I wasn't going anywhere because I knew I couldn't take the girls. You reminded me that if I ever tried to take them, you'd find me and you'd kill me. But for the first time, I progressed the conversation with logic. I said, okay, hear me out. You find me, you kill me. Then the girls wouldn't have either of us because I'd be dead and you'd be in prison. You said I wouldn't care because the girls would be with my family, not with yours. And I'd be chilling in my cell reading all day. I hope you use this time in prison to work on your anger. I hope you use it to reevaluate your priorities and who you want to be. I hope you use this time to become a completely different person, because the me that you knew is not who I am now. I will not cower in fear of you anymore. I will not strategically lie to you to protect my children anymore. I will stand up and I will loudly and destructively fight for them, or fight to protect them, even if it's from the monster who provided half of their DNA. So I hope you use this time wisely, and if not, I hope you have fun chilling in your jail cell reading all day. Because regardless of what you choose to do, whatever I have to do, whoever I have to fight, and whoever I have to keep out of their lives, my children will be shown nothing but love, protection, and happiness.
Just up. All right, Deputy Martinez, if you'll take Mr. Burke into custody this time.
And that's all I have, Your Honor.
Yes, thank you, Mr. Rose. Mr. Hartwell, can I return this victory check?
Thank you, sir.
Mr. Huggins? All right, this is a sanctions court hearing, CR 20-125. Kirkland Huggins. All right, Mr. Huggins, you were in sanctions court previously. Ordered to pay $65 to probation. My notes say you complied with that. to work 10 hours community service. You complied with that. To tenure counseling, and says that you have complied with that. Did you pay your court collections? Because that. Yes, sir. When did you pay that?
I paid it yesterday. I have it.
I'm gonna take your word for it, okay?
Yes.
All right, Mr. Huggins, I'm gonna reset you to September 30th. And the week prior to that, I want you to have paid 65 to probation, 40 to your court costs, work 10 hours community service. Where are you doing your community service?
I did the first 6 hours over there at the probation department, in their office and the entire lobby, all the glass windows, and then the other half I picked up trash on last week.
And then the fourth thing is just to continue attending counseling twice a month as required, okay?
Yes, sir.
Any questions about those things? All right, we'll see you back on September 30th. You'll sign this notice of appearance and then you're free to go.
Sir.
You're welcome. Mr. Carroll. Sanctions Court hearing for Bryce Carroll, CR 21-208. All right, Mr. Carroll, let's see. Last time we were in Sanctions Court, you were ordered to pay 60 to probation. You did that. You ordered to pay $300 to your court collections. You did that. It says that you came up short or you failed to comply with your 20 hours community service. Did you work any? Say it again. You did 21 hours? Where did you work 21 hours at? Which county?
Ellis County.
All right, you'll need to consult with your probation officer to make sure that they received those and that those were approved, okay?
Well,
I'm gonna have you come back on September 30th. And I want to do the same things, all right? 60 to probation, 300 to court collections. Remember, that's what you have to pay every month to expire on time, okay? And 20 hours community service, okay?
well,
But I want you to make sure that your community supervision officer has those 21 hours credited. Make sure that they've received that and that that's in a free place, okay?
well.
If not, it's gonna put you further behind.
Does he have any hours on that?
I don't know.
Okay.
So what happens is whenever you turn these things in, if they get transmitted to the probation department, then they make a report for me. And the report says that they don't have it credited right now. It could be that they sent it after the fact or after the deadline.
I think I seen her last week on Thursday. She said she would send it over. So
Last week on Thursday, it might not have made it here on time for them to produce this report today. So I'm just saying, give them a call, make sure that they've sent it over, okay?
oh,
Any questions? All right, free to go. Mr. McSpadden? All right, Mr. McSpadden, in your sanctions court hearing last time, we ordered three things: $100 to probation, $80 to court collections, and 20 hours community service. Each one of those was sanctionable with a day in jail for failure. This is what my report says. My report says that you failed to pay your $100 to probation. Is that right?
I paid the wrong thing, Your Honor. I didn't know that until this morning. The clerk called me and they gave me the receipt and they said as soon as it reverts back to my card, I can make a payment to the correct place. Apparently I paid downstairs instead of up here, the county instead of the district. And I have the receipt.
Do you have a case downstairs?
No, sir, I just online, I pushed the wrong button,
How much did you pay?
100 for each.
Shows her. And what about your 20 hours community service?
I turned in 126 hours, Your Honor.
When did you turn that in?
When I seen my probation last month.
Was that for this month or was that for last month?
That's all together, Your Honor. I think it had some days on it for this month as well.
So would you do 126 hours all at the same place?
Yes, sir. Help Hands in Hawkins.
Do you have records of that?
I turned it into the probation officer, Your Honor.
You said you turned that in last month?
This last time I reported, Your Honor, after we had sanctions courts last month.
And when was that?
I believe it was the 18th or something.
July 18th?
I believe. I can't. It's like the 21st, maybe.
Just to verify that.
Let's see how quick it's officer. Did you turn it to your officer?
Here?
in the
Wood County.
Wood County?
All right, I'll tell you what, go ahead and have a seat and I'll call you back up. Mr. Cheatham? All right, this is sanctions court hearing for Kaylin Cheatham, CR 22-205. All right, Mr. Cheatham, last time you were in sanctions court, I ordered $150 to probation, $100 to your court collections, and 30 hours community service. My records say that you failed on all three of those. Is that right?
I paid a little bit what I had to the courts. I got the receipt.
How much was that?
It was 50.
50?
Yeah, that was all I had.
When did you pay that?
It was 7/29/2025. And
What about, so you paid that to who? Probation or court?
court.
Okay, go ahead.
And for my community service, I don't know if you remember the last time I was here, but that job that I was telling you about when you was like, you need to find something better, when I was telling you about the community service for Dallas County. So I was driving for an owner operator, right? So they ended up, his wife had like a nonprofit organization. So she was letting me work and do the community service over there at the church that they have. But we ended up having a falling out, me and the boss, and he ended up terminating me without pay. And that made me I watched him take the paper from and rip it. I did at least 20 with them. But when they did that, that messed up everything that I had going. So my car notes behind. I got a notice to vacate. I finally started my new job last Tuesday.
What job was that?
To Teton Petroleum Transport. I'm hauling gas now. So it's kind of rolling, and I get my first check on the 22nd. They pay bi-weekly. And I'm off every Sunday and Monday. So now that I kind of was able to calculate a plan. So just come out here to do community service on Mondays when I'm off, and just
Sit off every what, Sunday and Monday?
Sunday and Monday.
And you start that when?
I started last Tuesday.
All right, Mr. Cheatham, this is what we're gonna do. I'm gonna have you come back on September 30th. $150 to probation. $150 to your court collections. 20 hours community service. And I'm gonna sanction you to 1 day in jail for your failure to meet your obligations that I ordered you to do last time.
Yes, sir.
Okay, I'll let you pick the 1 day in jail so that it doesn't interfere with your work schedule.
Yes, sir. I appreciate that.
To sign this and then come over here and meet with the probation officers. They'll get you a date. I'll back over here and go with Mr. West in there. Let's see. Mr. Duncan. All right, let's see, on 6/12, I believe you were sanctioned to pay 100 to court and 100 to probation.
Yes, sir. I didn't pay it. I got the money to pay it now. I told Larry, he just told me to tell you, I got the money to pay for the probation today.
How come you didn't pay it when you were supposed?
Well, I'm going to divorce and, moved out, got a house and got a job, better job. And to be honest, I just had too many things on my mind. Forgot to do it. I paid my court before all that happened, but there's no probation.
So have you paid it or you just have it?
I just had the money and Larry told me I'll go on up there and pay it when I see him today.
So how much are you paying today?
100, all of it.
You're paying 100 to probation and 100 to court?
I should already pay court.
Hmm?
I'd already paid the court.
When did you pay the court?
I had the receipt on my phone. It's been a while. I paid it on 29th, somewhere around in there. I should have it. I got a company phone here, sir.
That's fine.
I just don't know how to get to the pictures. Will my bank statement, approve it?
No, it's okay. All right, this is what we'll do.
Yeah, I got it. I just saying, I got it on my bank statement.
No, that's fine. So what I'm gonna do is I'm gonna order you to come back on September 30th. I'm gonna order 150 to court collections. 150 to probation.
Okay.
Then I want you to have proof of your $100 payment to the court and $100 payment to probation for either July or August.
I haven't paid this month yet.
I know. So I want you to have paid, I want to see your proof that you paid in July. You said you paid.
Yeah, I got it on my bank statement.
But you haven't paid probation. You've only paid.
Yeah, I'm fixing to pay my probation today for July.
All right, so that's fine. So that's what I want to see. I want to see the proof of your $100 that you're supposed to have reported to me today. See that on September 30th. In addition, 150 to court, 150 to probation.
Okay.
Bring your receipts, and I'm gonna do this. I'm gonna do a day in jail for each one of those that you don't do. Does that make sense?
Yes, sir.
So if you only pay $100, it's a day in jail. To probation, you only pay 100 to court collections, it's a day in jail. If you don't bring proof of your receipts that you were supposed to bring me today, then that's a day in jail.
Okay.
Okay? Do all of those things, don't have to worry about going to jail.
All right, I'm probably just gonna go right over here when I get up through here and get that for you.
However you want to take care of your business, up to you to take care of it.
Okay.
She's gonna have you sign this notice of appearance and ready to go.
You can just come back for you before I leave town, leave. I live out in some country.
You can bring all that to me on September 30th.
Yeah.
Mr. Willis? All right, Mr. Willis, this is Sanctions Court hearing CR 19-211. I believe the last time we were in Sanctions Court, I'd ordered some things, one being $600 probation payment, $145 payment to your court collection fees.
$600 for 60, you mean?
Mine says 600. I'm just reading the report.
Oh, yes.
Yeah, 600. And then 20 hours of community service. Did you do any of those things?
I got a 5-page report, community service.
You got what?
5-page report, community service.
What does that mean?
And because I was at the doctor in my heart, this is what it says, this is what I got.
What did we do on July 29th?
That was dismissed till today. I got a paper saying, don't show up the 29th, show up today. It was a reschedule.
Oh yeah, that's right. It's a week ago.
And I did all that same day that I paid those fines, the same day that I left on the last time that I saw you.
So you did all this, you paid your $60 probation, 140 to court collections,
Yeah,
and you wrote your 5-page paper?
yep.
All right, so Mr. Willis, I've got some bad news for you today. The probation department has submitted a motion to revoke to the DA's office.
Wow. If it's because of that machine, they want me to pay.
I think it's because you continue to drink alcohol.
No, I didn't. She told me I didn't anymore. Then I walked in and I found my wife and I called her and let her know that I did, but I hadn't drank anymore.
So this is what I want you to do. I don't want you to say anything else, okay? Because anything you say can be used against you in court, okay? And you've got prosecutors sitting right here. So there's been a warrant that's been issued. Deputy Martinez is going to take you into custody and
Can I ask for a week?
no,
Because I just yesterday, I swear to you, I can call them and let you know, they diagnosed me with stage 2 kidney failure. And I go to the hospital on the 25th.
I understand. We're going to have to take care of this business here today, okay? If you're indigent, then I want you to request a court-appointed attorney. Court will appoint you one. We'll get you a hearing. We'll see if we can't get it all resolved, okay?
I'm gonna lose my job.
You have enough funds to hire an attorney?
No, sir.
Then when you get out to the jail and they go through the paperwork, I want you to request a court-appointed attorney. Mr. McSpadden, we're just waiting on a return call on your community service verification, okay? Give it to me.
I'll take your number.
Who would you like to start with first?
Let's start with Mr. Vasquez.
That's not a plea, correct?
No, sir, it's just.
Mr. Vasquez, come on up. This is cause number CR 24-292 and 293, State versus Edgar Vasquez for docket call. Go ahead.
Judge, I think I'm gonna ask the court for an additional docket call. I'd like not to call it the final docket call, but if you need to, that's fine as well.
Is there any reason we wouldn't call it final?
Well, because I wanted an option to have an addition on that. But either way, I've got records I'm trying to go through and I'm working through them. You may ultimately have our resolution and, so final is fine.
All right, court, any objection from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Vasquez for a final docket call. How about this, Mr. Schmidt? I'll meet you in the middle and we'll move it to October.
Yes, sir.
October 14th. Court call CR 25-32, State versus Zachary Dale Campbell. Mr. Campbell was set on the court's docket for docket call today and also for pretrial noncompliance. Court finds that Mr. Campbell has been arrested and incarcerated in the Kaufman County Jail. The court will reset Mr. Campbell for September 30th for status. Kaufman County custody. Also, the court is finding Mr. Campbell's bail to be insufficient and has signed an order increasing bail to $100,000. Who's next?
Just we go through the pleas.
Ms. Mendez? This cause number CR 25-52, State of Texas versus Norma Linda Mendez. Ms. Mendez, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Ms. Mendez, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
What have you been diagnosed with?
Depressed since 1999.
You said depression?
Yes.
Are you currently on any type of medication or treatment for that?
Yes.
Do you feel like you have a rational understanding today of what's going on and that your depression is not in any way affecting your ability to understand that?
No.
Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes.
Do you have any questions about anything before we go further?
No.
Everything that you've read and signed, you understand?
Yes.
Mr. Schmidt, do you believe Ms. Mendez to be competent to enter into an agreement? And if so, do you believe that she's doing so intentionally, knowingly, and voluntarily after understanding her rights and the advantages and disadvantages of the deferred adjudication plea?
Yes.
All right, Ms. Mendez, you are charged by indictment with a third-degree felony offense of assault of an EMS personnel. Court finds that that is a third-degree felony, which carries a range of punishment of not less than 2 years in prison, up to a maximum of 10 years in prison, and up to a $10,000 fine should you be convicted. I see the plea agreement is upon you pleading guilty. The state's recommending that the court defer a finding of guilt, place you on 3 years of community supervision, assess a $1,000 fine, court cost of $290, reimbursement fees of $535, and restitution in the amount of $1,370.36. Ms. Mendez, is that your understanding of the plea agreement?
Yes.
That's what you're asking the court to approve?
Yes.
Ms. Mendez, this time, how do you plead to assault of an EMS personnel?
Tom?
He's asking how you plead.
Oh.
You're not guilty.
Well, I guess guilty.
And you say that you guess guilty, does that mean?
Well, because I don't recall what happened, but due to my alcoholism.
Okay.
And so, then with this, I pleaded not no contest because I don't remember the incident.
And you're saying that you were intoxicated at that time?
Yes.
And it was a voluntary intoxication?
What do you mean? Well, I chose to drink because I thought it would calm me down to be away from my home. I can't be away from my home long.
Okay, so it was a voluntary intoxication, meaning you were not drugged.
No.
Court finds that voluntary intoxication is not a legal defense. Ms. Mendez, has anybody, the court will accept the defendant's plea of guilt at this time. Ms. Mendez, has anybody threatened you, forced you, or pressured you to plead guilty?
No.
All right, court having accepted defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
From the defense?
Yes.
Court will review the evidence.
What?
No. Asking questions like that. Get confused.
Oh, well, you understand now.
Yes.
All right, court having reviewed the evidence, finds enough evidence to convict the defendant. The court will follow the plea agreement. Court defers the finding of guilt, places the defendant on 3 years community supervision, assesses a $1,000 fine, $290 court cost, $535 reimbursement fee, restitution in the amount of $1,370.36. Ms. Mendez, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with Sergeant Martinez. After that, you will meet with the probation.
No one takes it.
Mr. Bennett, go ahead and make your way forward, please. Mr. Bennett, come on forward, please.
Hey, I'll go.
All right, court calls. Cause number CR 25-3, State versus Douglas, Wayne Bennett. Mr. Bennett, if you'll raise your right hand, I'm going to place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may lower your hand. Mr. Bennett, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done as your attorney?
Yes.
Do you have any questions about the paperwork that you signed or anything else?
No.
You understand everything that you've read and signed?
Yes.
Mr. Schmidt, do you believe that Mr. Bennett is competent to enter into an agreement? If so, that he's doing so after you've explained to him his rights regarding this case?
Yes.
All right, Mr. Bennett, I see that you are charged by indictment with a third-degree felony offense of tampering or fabricating with physical evidence. However, the plea agreement today would be to a different charge. It would be a lesser included Class B misdemeanor offense of interference with public duties. A Class B misdemeanor carries a range of punishment of up to 180 days confinement in the county jail and a possible fine not to exceed $2,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court convict you of the lesser included offense of interference with public duties, assessing your punishment at 6 days confinement in the county jail, for which you will receive 6 days of credit for time already served. In addition, you will be assessed a $500 fine, court costs of $270, and reimbursement fees of $35. Mr. Bennett, is that your understanding of the plea agreement? Understanding those things, how do you plead to interference with public duties?
Yes.
Are you pleading guilty because you are in fact guilty of committing that offense?
No.
No?
I plead no contest.
Mr. Schmidt, is that a part of the agreement with the state for the defendant to plead?
No, sir, we have not addressed that as part of the agreement. If I might have just a moment. With my client.
I change it to guilty. Yeah.
All right, so Mr. Bennett, I'm going to ask you again, are you pleading guilty to this offense because you are in fact guilty of committing the offense?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
The evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the lesser included offense of interference with public duties. Court hereby convicts Douglas Wayne Bennett of the Class B misdemeanor, assesses punishment pursuant to the plea agreement at 6 days confinement in the county jail. Mr. Bennett will receive 6 days credit for time served. Court orders him to pay a $500 fine, $270 court costs, and $35 in reimbursement fees. Mr. Bennett, if you're not able to pay all of those today, then you are ordered to report to the district clerk's office and talk with them about setting up a payment plan. Failure to pay your costs will result in the court issuing a warrant for your arrest. Do you understand?
I understand.
All right. All right, Mr. Bennett, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted. After that, you are released. Ms. Bennett, come on up. Mr. Schmidt, will Ms. Bennett be taking a plea in each case?
Yes, sir.
Okay. All right, Ms. Bennett, court calls cause number CR 25-4 and CR 25-178. If you'll raise your right hand. Ms. Bennett, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. So, Mr. Schmidt, I show that Ms. Bennett is set for arraignment today on driving while intoxicated. This is her first setting on that. Is that correct?
That is correct.
But she will be entering a plea to that charge today.
Yes, sir. That facts and circumstances surrounding the DWI are the same as the
Growing mischief. Okay. All right, Ms. Bennett, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done?
Yes.
Do you have any questions about anything that you've read and signed today?
No, sir.
In cause number CR 25-178, you are charged by indictment, I believe. Is that indictment or information, Mr. Schmidt? Indictment. You're charged, it says information, is that correct? That is correct. Okay. You're charged by information with a Class B misdemeanor offense of driving while intoxicated. That does carry a potential range of punishment up to a maximum 180 days confinement in the county jail and a fine, if imposed, up to $4,000. In cause number CR 25-4, you are charged by indictment with a third-degree felony offense of criminal mischief greater than $30,000, less than $150,000. A third-degree felony does carry a range of punishment of not less than 2 years in prison and not more than 10 years in prison, and a possible fine not to exceed $10,000. Do you understand those ranges of punishment?
Yes.
I see that in your felony charge of criminal mischief, the plea agreement that's recommended by the state is that the court consider the evidence, defer a finding of guilt, not convict you, placing you on 10 years of community supervision with restitution in the amount of $29,228.55. In addition to that, you would be assessed court cost of $290 and reimbursement fees of $535. Is that your understanding of the plea agreement in that case?
Yes.
And in the driving while intoxicated, the recommendation is the same upon your plea of guilt, that the court defer a finding of guilt and place you on community supervision for 2 years, including a $100 EMS trauma fine, a $3,000 DWI traffic fine, being probated, and would only apply if your probation is revoked and your conviction becomes final. In addition, the state is asking the court to dismiss and take into consideration a possession of marijuana less than 2 ounces that is unfiled in the DA's office. In that case, you would also be responsible for $270 in court costs and $20 in reimbursement fees. Is that your understanding of the plea agreement in the DWI case?
Yes, sir.
Mr. Schmidt, have you explained to Ms. Bennett her rights as they pertain to each one of these cases, including the advantages and disadvantages of a deferred adjudication plea? And do you believe that she's entering into the agreements intentionally, knowingly, and voluntarily?
Yes, sir.
Ms. Bennett, how do you plead to the charge of criminal mischief?
Guilty.
How do you plead to the charge of driving while intoxicated?
Guilty.
Are you pleading guilty to each one of those crimes because you are in fact guilty of committing each crime?
Yes.
Has anyone threatened you, forced you, or pressured you today to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt in each cause. Mr. Schmidt, any objection to the evidence offered in each cause?
No.
All right, the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, court will review the evidence. All right, the court, having considered the evidence in each case, finds sufficient evidence to convict the defendant. The court this day will follow the plea agreement between the state and the defense. In cause number CR 25-4, court hereby defers the finding of guilt on the third-degree felony offense of criminal mischief greater than $30,000, less than $150,000. Court places Ms. Bennett on 10 years community supervision, ordering her to pay restitution of $29,228.55. Court assesses $290 court cost, $535 in reimbursement fees. In cause number CR 25-178, court follows the plea agreement. As to the charge of driving while intoxicated, a Class B misdemeanor, the court defers a finding of guilt, places Ms. Bennett on 2 years community supervision, orders her to pay a $100 EMS trauma fine. Court will assess a $3,000 DWI traffic fine, but that is probated at this time and will only apply if the defendant's probation is revoked and conviction becomes final. Court does assess court costs of $270 and reimbursement fees of $20. and the court will dismiss and take into consideration DA 2024-0732, possession of marijuana less than 2 ounces. Ms. Bennett, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Sergeant Martinez. After that, you will meet with the probation officers. Who's next, Mr. Schmidt?
Yeah, approach, Judge.
Yes. Yeah, on the record, all. Mr. Richardson, come on up. This cause number is CR 25-12 and 2024-219. We were set for Mr. Richardson to enter a plea before the court today. Mr. Schmidt, you've indicated to the court that Mr. Richardson at this time does not wish to plea. Is that correct?
That is correct, Judge.
And so the court finds that Mr. Richardson is and has been on the court's jury selection docket, and he will remain so. And so he'll need to appear on September 8th for his notice of appearance. All right.
Mr. Waters, for all intents and purposes. This will be able to sign. Go ahead and type that real quick.
Yes, sir. That's your last one.
Yes, sir.
All right, court call State of Texas versus Pascal Todd Waters and cause numbers CR 25-20, 2024-409, 2025-13, 2025-14, 2025-245. Mr. Waters, sir, raise your right hand. Other hand, there you go. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Your name is Pascal Todd Waters, is that correct?
Yes.
And Mr. Waters, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
What have you been diagnosed with?
Bipolar.
Okay. Are you currently on medication or treatment for
Yes.
bipolar? Do you feel like you have a rational understanding of what's going on in court here today?
Yes.
Do you feel like in any way your diagnosis of bipolar is interrupting or affecting your ability to rationally understand what's going on? Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him and the work that he's done as your attorney?
Yes.
Do you have any questions about any of the paperwork that you've read and signed?
No.
Mr. Schmidt, do you believe Mr. Waters to be competent?
I do, Judge.
Do you believe that he is entering into this agreement intentionally, knowingly, and voluntarily?
Yes.
And have you explained to him the advantages and disadvantages of a deferred adjudication plea? Mr. Waters, you are charged by indictment in cause number CR 25-20 with a third-degree felony offense of evading arrest or detention with a vehicle. A third-degree felony offense in Texas has a range of punishment. If you were to be convicted and sentenced, it would have to be not less than 2 years in prison and not more than 10 years in prison. And you could also receive a fine not to exceed $10,000. Do you understand that range of punishment?
Yes.
I see that the plea agreement in your case is upon you pleading guilty to evading arrest or detention with a vehicle, the DA's office is recommending that the court not convict you today, rather to defer a finding of guilt and place you on 10 years of community supervision. During your community supervision, you would also be assessed a fine of $1,500, court costs of $290, and reimbursement fees of $535. All of the other cases that you've been indicted on that I've announced would be dismissed as part of your plea agreement in this one specific case. And you would have to serve 90 days in the county jail as a condition of your community supervision. And you would get 11 days credit towards that 90 days. And then the remaining days you would have to meet with your probation officer and figure out what days during your period of probation you would go and serve the remainder of that. And you would also be placed on the mental health caseload. Do you understand all of those things?
Yes.
Okay. Any questions about anything before we go further?
No.
Okay. All right, then, Mr. Waters, the court having explained the range of punishment and the plea agreement, at this time, I would ask you, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened you, forced you, or pressured you to plead guilty?
Yes.
They have?
I plead guilty to.
Right, but I want you to listen to my question. I understand you're pleading guilty.
Yes.
But has anybody threatened you to plead guilty?
No.
Has anybody pressured you to plead guilty?
No.
Has anybody forced you to plead guilty?
No.
Okay, very well. Then the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objections to the stipulation of evidence?
No, sir.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then the court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement and recommendation from the state. Court hereby defers a finding of guilt on the third-degree felony offense of evading arrest or detention of a vehicle. Court places the defendant on 10 years community supervision, orders him to pay a $1,500 fine, $290 court cost, $535 in reimbursement fees. The court orders the defendant to serve 90 days confinement in the county jail as a condition of community supervision. The court will credit Mr. Waters with 11 days of credit time already served. Court will order him to serve the remaining 79 days. And he is ordered to do that in conjunction with the Van Zandt County Community Supervision and Corrections Department. And he is to be placed on the mental health caseload. So, Mr. Waters, you will meet with your probation officers and work out when you're going to serve the remaining 79 days. You do understand that?
Yes.
Okay. All right, Mr. Waters, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I want you to come up here and Sergeant Martinez is going to take your fingerprint. After that, you'll meet with the probation officers.
All right.
Just go right over there.
Mr. Powell, Mr. Waters. What minutes of August 21st?
All right, thank
And I didn't announce, let me announce this for the record, Ms. Grisham. The court failed to announce that the other cases announced by the court are dismissed under section 1245 of the Texas Penal Code.
Appointment, Jarvis.
All right, I believe that does conclude the court's morning criminal docket. The court is going to stand in recess for the lunch period, and we will resume at 1:30 with the criminal docket this afternoon from the Van Zandt County Justice Center.